Welcome to the Kentucky Auto Accident Podcast. Louisville attorney Jim Desmond has been handling injury cases related to traffic accidents for over 20 years. Jim will provide valuable information to help you and your family. He wants you to understand the important issues you need to know when it comes to handling car accidents and motorcycle wrecks in Kentucky. There's a lot riding on this, so let's get started. All right, well, today we're going to switch it up a little bit. Today we're going to do sort of a frequently asked questions episode. And the reason is, Jim, you're getting a lot of questions on basic stuff that we've covered in the past, but a lot of times it's repetition, and sometimes these other questions are just unique. So let's go ahead and jump in if you don't mind. So today, obviously, Jim Desmond, welcome back to the studio. Glad you're here.
Thanks,
and
sir.
We've also got Colleen in the studio. So from time to time, if you're listening, you hear a young voice coming on the mic. There is a third person in the studio today for the first time in quite a while. So, all right, Jim, how you been? What's going on?
Good, and we're doing pretty well these days and everything. But, you know, one of the reasons we want to do this one, as you said, we've gotten some responses from the podcast that are asking questions. So kind of going back, as much as we're throwing information out there, I've been trying to write some of these questions down and say, okay, what are they generating? So it's going to be fast and furious a little bit today, but, you know, let's see what we can kind of come up with and try to address the specifics. So,
and again, you're going to talk primarily about car wrecks, maybe some motorcycle wrecks thrown in here. You're licensed in Kentucky and also Indiana, but it sounds like the bulk of your practice is still right here in Kentucky, although in Louisville we're kind of right across.
It is, and it's all about car wrecks. But again, and we've, you know, for the last, 12 podcasts or so?
Something like that, yeah.
You know, we've been talking just about car wrecks, and so hopefully this stuff the questions will take what we've talked about before and kind of put it a little bit more into real-life examples and clarify it again a little bit. So,
well, let's jump in then. And this is kind of an interesting question, which is it's very direct, and it just makes sense. Do I have a personal injury claim if I don't have car insurance?
And the answer is yes. And that's one of the biggest things people mess up with. I actually just settled a case where, again, and I blogged about this one, Jim, you know, but
Yep.
the two law firms, very prominent ones, I won't say, turned down this lady immediately, okay, and said because she didn't have car insurance. Well, in Kentucky, if you don't have car insurance, you cannot recover the first $10,000 of your medical bills. That's the penalty. In Indiana, there's no such penalty. So if the other driver is at fault and insured, then you still have a personal injury claim. You still have a property damage claim, okay? So the only difference is in Kentucky, you're penalized and cannot recover the first $10,000 of your medical bills or lost wages. So, for example, in this lady, she had a $70,000, this goes back to what we talked about so many times about underinsured issues. Yeah. She had a $70,000 medical bill. We had an out-of-state driver that had policy limits of $30,000, okay? And we were able to recover the $30,000. We took the $70,000 medical bill. We paid it through the health insurance. They asserted a subrogation lien, saying they want part of what they paid back. We got that negotiated down to almost a minimal amount. Okay, and she walked away with the majority of the $30,000.
Wow.
Okay, so but again, two firms told her she didn't have a claim, which was wrong. And of course, her car got fixed as well. Well, not fixed, actually, it got totaled out. It was she got paid for the value of the car. Okay, you know, and we went from there. And you know, this is a great example of everybody wants to act like, okay, you're trying to get rich from a personal injury suit. She didn't get rich. And as a matter of fact, the copays and deductibles, as well as the fact that now she's got to go buy a new car, will eat up the majority of any money she got. But she did get something when other people told her no, she didn't have a claim just because she didn't have car insurance. And
well,
that's
and
not
more
true.
importantly, she's not having to come out of pocket to get all of that fixed.
Right.
I mean, because you were able to get that settlement. So now she has funds to draw down. But, I mean, had she not even done that or taken the advice of some of these other firms, that would have all been coming out of credit cards or the bank account or savings or somewhere, right?
Well, and that's the problem. Think about it. If you submit a $70,000 bill to health insurance, you're probably dealing with anywhere from a $3,000 to $5,000 copay.
Yeah.
So again, that is something now she at least has the means of dealing with that. And again, you know, people say, well, you know, now let me explain something. Okay, her case was, well, let's go a little farther on this. Did she have a personal injury claim despite being uninsured? Yes. Her claim was worth, with the $70,000 medical bill, and I recovered $30,000 because that's all there was. I mean, let's say she had another $50,000 in coverage. Okay.
Right. Well, you started off saying the $30,000 was policy limit, so the at-fault driver had an insurance policy that was up to $30,000 for coverage.
Right. Okay. So we recovered the maximum.
Yeah.
But the point being is, if she had her car insured, not only could she have recovered the first $10,000 of medical bills, but we could have made that underinsured claim we talk about so many times, saying, look, my client's damages are way above what we're recovering, and so now I can go against her own insurance and try to recover more.
And that first $10,000, that is that Kentucky no-fault policy, right?
Correct.
That's the PIP coverage that we've talked about in other episodes.
Right. Right.
Okay.
In Indiana, that doesn't have that. Remember, Indiana's a med-pay state.
Yeah.
So, again, if you don't have car insurance in Indiana and you're in that same scenario, you don't get penalized. Okay. Should you have it for every other reason? Yes, because not only the criminal aspect of it with the driving without insurance, but, again, if you get hit by somebody who has no car insurance and you don't have car insurance, you're out of luck. Or go ahead.
In your answer to this issue about the personal injury claim, you said you used her insurance. So let me jump into the second question, because I think this dovetails exactly with what you said there. Somebody asked, why do I have to use my car insurance for the medical bills if I was not the at-fault driver, or if I was not the one who caused the wreck? That makes a lot of sense. I think a lot of us scratch our heads going, you hit me and I have to use my insurance for something?
Right. And everybody, two things on it. Okay, in Kentucky, the idea is this. The whole idea behind no fault is you should not have to show fault or liability on a driver to get your medical treatment. So what do? They say, look, if you get in a car accident, period, no matter how it happens, okay, you're immediately entitled to this $10,000 of medical expense coverage we call no fault insurance. And it's actually it's not just medical expense coverage, it's lost wages and what we call replacement loss services, everything else.
And that's for the passengers in the car as well, right?
Exactly, everybody. So again, I always tell my clients during the first meeting, they come in, what no fault means is we go down the block, I'm standing still, hit in the rear end by a drunk driver, my insurance company is responsible for everybody's medical bills up to $10,000. It doesn't mean they can't recover it back from the drunk driver, but they got to pay it up front.
And the idea is we want to try to get that money dispersed quickly so you can go to the ER, or you can go somewhere and make sure that there's funds available for some of this.
Yeah, I wouldn't say dispersed, but yes, the idea is you can do something immediately with it. Okay, I won't say her name, but my daughter was just in an accident, 2 accidents in May. First,
she's okay.
She is, but the first one, again, because even though she was out of state, she was in my vehicle, and again, as you talk about with the no fault, that no fault coverage follows her. So I said to her, again, I said, look, if you're hurting, go to the hospital, okay? Yeah. I know it can be paid for. I don't have to worry about somebody being out of network and all this other stuff, with health insurance. I'm like, go ahead and go. That's the advantage of it. The reason we don't have a choice but to use that in Kentucky is the law says, in exchange for that right, we give up the right to recover the first $10,000 in medical bills. So if I went to State Farm and said, okay, I've got a client, I've got $5,000 in medical bills, give us $7,000 to settle his pain and suffering claim, and give me this other $5,000 for a total of $12,000. They would say, well, we will pay you for the pain and suffering claim. We'll pay the $7,000 maybe, okay, but we're not going to pay the $5,000 in medical bills.
Because you're going to get it through no fault anyway.
Because my client doesn't have the legal right to recover it, and if that right is so strong to obtain no fault insurance, what you just said is right, which is I could settle that claim, I could get the whole $12,000. Let's say State Farm says, okay, we'll do that, and I could still go back and get my no fault insurance. So State Farm could end up having to pay twice.
Right.
That got a little confusing. But the bottom line is it's not my legal right to recover the first $10,000 in medical bills. It's the right of my insurance company. And so I have to use that basically to make it happen.
But again, that's to your benefit typically because you've got some coverage already built in. You don't have to wait until this case gets resolved to go get your broken leg taken care of.
Right.
You've got money right there.
Right. And that's the thing, again, that's one of the things all of these other podcasts kept talking about that you're kind of hinting at again. The other part about using your own car insurance is you got to understand the law is not fair. You got to understand you have to put on your own car insurance what coverages we think you need ahead of time, because there is no guarantee the guy has insurance, or has enough insurance. I've used the example before, but I love it. I use it all the time. If you lose your left arm and you're hit by a UPS truck, fine, we're okay. If you lose your left arm and you're hit by a 1980 Chevette, we're in trouble.
It all just may not be enough coverage there.
Right. It's not an issue with a lawyer. It's not an issue with the damages. It's not an issue with your medical bills. The first question is who is insured and for how much. That really is the first question of any car accident. And again, that's why we preach and say on your own car insurance, have this kind of policy coverage.
Right, which comes back to the uninsured and the underinsured, the UM/UIM coverage that you talk about all the time.
Right, and that's to have at least $100,000 per person because, again, to recap, the uninsured says, okay, guy has no insurance. Your insurance acts like they insure him. The underinsured says, okay, okay, we recovered the maximum, like we were talking about earlier with that one lady of the 30, but it's still not enough, okay, because medical bills, lost wages, whatever it might be, out-of-pocket expenses, and we can go then and recover the balance of the value of the claim from her own insurance.
Through the
underinsured
UIM coverage.
Yeah.
Yeah, okay, that makes sense. Here's a question that comes in a lot, I would imagine anyway. How do I get my car fixed? I'm in a fender bender or I'm T-boned or whatever. How do I go about getting the car fixed? I understand some of the medical, but what about my car?
Well, that's the thing. The car is, if I can get a client's car going, that's usually what buys me the quickest amount of peace. Okay. But the problem is this, all right? So you're at the accident scene, all right? And sometimes the police come these days and sometimes they don't because of the COVID stuff.
Right.
Even if they come to the scene, they get all the insurance information, and then you're waiting for the police report, because the police report is what has that other person's name and insurance information. So even when we get that claim, we get the police report, then I go call Geico and I say, I want to open a claim for my client. They still have a reasonable amount of time to investigate it. They don't, unless this other person that hit you, unless he steps up to the plate and says, hey, I was at fault, there's no question, I rear-ended the person, whatever it might be, they have a reasonable amount of time to investigate it. So your car is sitting there is the problem.
Right.
You have two ways of getting your car fixed. Either one, you do that, you go against what you call the liability carrier, the other person's insurance, and you have to wait a little bit and hope you can get them what information they need, that they can basically get hold of their person as well as any witnesses and accept fault, okay, to get the car part going. Or two, if you have your own coverage, if you have a collision coverage, then you can go ahead and use that, okay?
The only so collision coverage on your own car if you've got that as part of your
through
policy.
your own insurance again,
yeah.
Okay, which I know everybody says, well, it's not my fault, but again, get rid of this concept that the law is fair. It's not. If you use your collision coverage, you're out your deductible. That's the downside right off the bat, okay? But you can get that back if the other person accepts fault down the road, if the insurance company does, you can get that back down the road, okay? But it does get it moving faster.
Right,
but
because you may not be able to get to work. Maybe you're not banged up that bad medically, but you still don't have a car to get to work or to do other things, to get the kids to school or whatever you need to do. So getting that vehicle, back on the road is important.
Well, and that's the problem sometimes too, because people want to go rent a car, but if you go rent a car at $40 a day and then the insurance company tries to say, well, we only cover up to $25, then all of a sudden you have other issues.
Well, okay, that's a great segue. Somebody asked, how do I get the rental car extended? I guess that's what they're talking about, is that, hey, I've got it for a few days, I've exhausted that, my car's still not back from the repair shop or the mechanic or whomever. How do you get that extended?
Well, if the car is fixable and it's at a repair shop, then it's not that hard to get it extended, because the body shop should be talking to the insurance company saying, hey, look, we need longer, parts took longer, whatever it might be. Okay, there shouldn't be a whole lot of issues. The problem you run into is when the car is a total loss, okay? And if it's a total loss, they owe you fair market value. They're not going to fix the car. They owe you what the car was allegedly worth the day before the accident.
Not replacement value. It's fair market value, which is a big difference, and that surprises people.
Right. Well, so that's the problem again. Well, I was trying to think. I was trying to use that same case, but I can't. But the short story is yes. So again, you have a 10-year-old Ford that you've just put some money in, and you think you can get another 7 years out of it, and they say it's still only worth $6,000. You're going to get the $6,000, not the $15,000 it takes to replace it.
So now go buy a $6,000 car and feel that you're somehow made whole. It doesn't work.
It's one of those areas that people lose out in the law. Yeah. That's another reason. I mean, it's one of the. There's no real way around that one, unfortunately.
Right.
You can argue the car is worth more. You can include your repair receipts. You can get a dealer to sometimes say, okay, they would, instead of $6,000, they would say the car would sell for $7,900 in their lot, something like that. But there's no way to really get around it. The rental car issue is when they total a car out, they are going to limit how long they're going to tell you got to get the title to them, and they're going to limit how long you can have that car. And the average pretty much is anywhere from 10 to 14 days from the date of accident, or less.
So we can have 2 weeks to get the title to the insurance company.
Well, yeah, but you're going to have. They're not going to say. They're not going to say we're going to give you longer because it's taking longer to get the car, or that you took too long to mail the title. There's a lot of there are some nuances, and I'll call on behalf of my clients and talk to adjusters and say, hey, will you, and do this and that. But that's for the purpose of this podcast, people need to understand if your car if his car is a total loss, and even if it's your own car insurance and you got rental car coverage, there's a limited amount of time they're going to cover that. Okay, so even a friend of ours, I won't say the name, but somebody you know as well, just got in a car wreck, and basically he was using his rental car coverage because, again, the car was a total loss.
Right.
Even though the policy talks about 30 days, there's a provision in there that I think they cut it off after 10 or 14 days.
Because it was total. There's not a question
It was total. They made an offer. They accepted the offer, so they don't have to go the full 30 days.
Right.
Okay.
So there are some limitations on all of these policies.
Yeah. So,
if you're in the automobile accident and the other insurance is not accepting fault right away, so again, now we're starting to drag this out a little bit. What should the driver do? What should we'll call him the victim at this point, what should he or she begin to do, again, if the other insurance is not accepting fault right away?
Well, and then that's,
or the other driver, I should say.
No, that's okay. One of the advantages of talking to any attorney right off the bat is you should actually open the investigation, because like one of the things I've done lately is the new development is this the Ring doorbell cameras.
Mm-hmm.
Okay.
Yeah.
So many times if we think it's going to be an issue, we'll send an investigator out and say go canvass that area, and we'll find sometimes we can basically get video of the accident or right before the accident. That helps a lot, because the other thing is that when you're at the scene, get the statements get the witness's information, and don't rely on the police officer. I remember we talked extensively in that podcast about that, because again, we don't know if it's going to be in the police report, or I've seen police reports that'll have they'll say Mary and phone number, and the phone may change or something else. So you want to be able to get hold of this person. You want an address, a name, that type of thing. Because again, I have a private investigator that can always run a trace and try to track that person down to get a statement. If you're waiting for them to accept fault, they have a reasonable amount of time to investigate the claim. They have a reasonable amount of time to talk to their insured, okay, and see what happened. The problem is, how do you force that forward? You just try to give them as much information as you can, okay? Right. So, for example, I always tell my clients, send me every picture you've got of the accident scene or your injuries. Let's get that all over them. Let's get the title ready, show them that you're the title owner. Let's go ahead and have my investigator do what I just talked about, where we can say there is or is not other stuff. We might do a recorded statement with the insurance company. I don't... Whether you do a recorded statement or not, that again, it depends upon the circumstances. If it's disputed fault, to do a 20-minute recorded statement and you do it wisely and understand your statement, what you say can be used against you down the road, then I think that helps a lot sometimes.
And would you be on the call for that typically? I mean, is that something you would normally do?
Yep, I just did one yesterday. It was 20 minutes long. My client did really well. I didn't have to say much. But we have somebody saying who had the red light, who had the green light.
Right.
And so they wanted to get my client's version. We had already faxed them the police report. As a matter of fact, we already faxed them all the photos we had. I was trying to think what else we did on that. We did look for the video. There was a Thornton's that did not have it. Again, you go in there and ask.
Yeah.
There was a Thornton's that had security camera, but not on the street. It doesn't go that far, unfortunately.
Well, and that's one of the things with any kind of accident. You've really got to move on this a little bit more quickly than you might realize, because if that video camera is on a loop, I mean, some of that footage, which could have been perfect for your side of the situation or your side of the case, may be taped over, recorded over. So you got to be careful with that. So don't wait around, right? And
I understand the naysayers, want to say, okay, you're making a personal injury claim, or I'm not that kind of person, all this other stuff. The thing that no matter how the accident happens, or whether you decide to make a claim, you got to understand from day one, you're preparing for the possibility that you're going to be in a lawsuit 2 years from now.
Yeah.
Okay. Because at the accident scene, you think, oh, it's clear cut. Well, then the guy goes back to his insurance company and says, no, I think this other person did this or that. Now it's not clear cut. Your injuries the same way. You want to say, well, I think I'll heal. Well, you wait 3 weeks. It looks like you weren't hurting in those first 3 weeks after an accident. So you have to literally, plan for the possibility that, okay, I've got my ducks in a row should this thing proceed to a lawsuit a year or two from now.
Right, which is why you gather all that information. You may not ever have to use it all, but it'd be good to have it up front.
Right. Yeah. And that's why I tell my clients again about the pictures and the bruises and everything else, because that's why I like these clouds, because I tell them, send me everything, because what do? I save everything to a cloud.
Yeah.
So I've even had clients that have come back a couple times, and then when we deal with a new claim, we still have medical records or something else from the old one that we can use, because an insurance company will say, well, didn't you claim back injuries before or something? And like, yeah, but this is why it's different. See the medical records.
And here's all of them. Yeah.
Right.
Well, okay, so you just mentioned something that surprises people. You said, this could go long, and maybe this is 2 years trying to get this case resolved. In the meantime, if I'm injured, I've gone to the hospital, I've blown through my $10,000 worth of no-fault coverage that Kentucky gave me, and now I'm starting to get medical bills because I was in the hospital. I was seen by maybe an ER doc. I was maybe shipped up to the ICU, so I had a whole bunch of stuff going on. Why would I involve my health insurance if the other side hadn't paid my medical bills yet? I mean, because they're waiting to get this thing settled before they start, paying these bills. But these bills are coming to me. Why would you have your own client use his or her medical insurance, health insurance?
The first step that they realize something: the other side doesn't pay anything until they pay everything at once. Okay, they want to dispute everything under the sun. So it's not, the process is not, okay, you're in a car wreck, and yes, our guy was at fault. He hit you in the rear end, or whatever it might be. So we'll pay your doctor visits. They don't do that because they don't want to be paying 3 or 4 little $50 doctor visits, and on the 5th one, the doctor says, "Oh, yeah, by the way, we need surgery from this to fix it. It didn't go the way we wanted it to." So, as far as the other insurance company is concerned, they're pretty much ready to dispute every aspect of your claim from day one. Okay, even if they accept fault for the wreck, they're going to say, "Well, is the condition related to the car wreck? Okay, is it related to your pre-existing conditions? And if it is, all related, well, was surgery necessary? Well, maybe our doctor would say otherwise." So they're not going to pay anything until they pay everything at the end. Your health insurance ultimately, and of course, when you go into hospital, I went in the other day for my son. And the copay was paid by a credit card before we were seen.
Yeah.
So, immediately you're going to have to use your health insurance really no matter what. And the thing about a health insurance, I don't like health insurance carriers, I'll be straight with you. All right, well, because one of the problems I have is if anything gets paid by them or it doesn't get paid by them, or if you don't go ahead and go through the paperwork and get Anthem to say, okay, they didn't pay anything, I can settle a case, and 6 months from now, they'll send me something saying, "Oh, we think we paid something," and I'll have to show them they didn't pay it, okay? But your health insurance has a lien against the case and says, "Hey, we have a right to get our money back." But again, back to the lady with the $70,000 bill, I think the health insurance ultimately paid out $18,000 to satisfy that bill, roughly. Okay. So again, I'm not sitting here trying to negotiate with the hospital to get them to take less. The health insurance has already done that. Okay.
Because they have their negotiated rates. So if
right.
Humana or Anthem or Aetna or something, they've already got their own rates, so those may be much better. So go ahead and use yours.
Go ahead and use it.
Preserve some of that money.
And some of them don't have great rates, but then you got to fall back and you got to try to negotiate it.
Yeah.
But again, and health insurance is supposed to be secondary to no fault or PIP coverage. PIP is the same thing as no fault, personal injury protection. A bunch of different words for it. But again, like one of the best things I think has worked for me lately, and I continue to do this, is reserve the no fault coverage. Okay, reserve it. Say don't pay it, because again, if you've got a $30,000 hospital bill, okay, and you go to U of L and you got a $30,000 hospital bill, if they grab the $10,000 in no fault coverage, the client still has a $20,000 bill.
Exactly.
What are they going to do with that $20,000 bill? They're going to submit it to health insurance anyways, right? Well, if you reserve the no fault coverage, then that $10,000 can be used to either pay the copays or deductibles from that $30,000 medical bill, or the health insurance lien afterwards, where we say, okay, look, the health insurance says, we want $6,000 back. We can use that to pay it. Again, I've said this to you before, and I've said it in the podcast, but I used to say this all the time where my clients are tired of hearing it. One of the biggest problems with the TV advertisers, they all act like, okay, the TV personal injury attorneys, I should say more correctly, they all want to say it's all about how much I get you with the right hand. That's only half the equation. It's how much I get you with the right hand and how much do I keep people out of your settlement with the left hand. And when I use health insurance, I'm stretching a dollar bill, okay?
Right.
Because, again, it doesn't do me any good to get a client $100,000 and have $99,000 go to somebody else, so.
Right, because at the end of the day, they're just not going to have anything left. And so if you can negotiate that and help your client work through that process or do it for them, they're probably better off. Which brings up something I think is an interesting question. I'm sure you get this all the time. Is the attorney fee negotiable? I mean, you're on a contingency fee. Let's talk about that real quick.
Sure.
And then, is that fee negotiable?
Okay, yes. Any attorney's fee is negotiable. Okay, now
It may be a short negotiation, but it's
well, let me explain. Okay, when we say negotiable, there's no federal law, state law that says you have to charge this much or anything else.
Right.
You get into Scott. Remember, Scott Shanos did that workers' comp podcast with us.
Yeah.
That's different. Okay, but a typical personal injury car wreck case, there's not any set fee. All right, the standard is 1/3 of what you recover, 40% if it goes to a lawsuit. Okay. A contingency fee means, again, the client owes you nothing unless you recover something. Okay, so that's why you're charging 1/3 because, well, I just had a case that we got settled and it went very well, but it took me a year to do it, and the first 10 months, it looked like it was going to be a zero case where I would have been out probably about $1,200-$1,300 in expenses alone, okay?
Right.
Because we couldn't find insurance coverage, and we finally found this one very elusive policy on the automobile dealership, okay?
Right.
So, but a contingency fee is, again, they don't owe me anything until I recover something, okay?
And of course, just from the Kentucky bar standpoint, you have to say that court cost and other expenses may be also the responsibility of the client.
Right.
So, I mean, but all that kind of rolls up, and you're going to explain all of that to your client ahead of
Well,
time.
and the Kentucky bars, that's why we have you sign. A lot of my clients, I wouldn't probably even worry about it, except the Kentucky bar requires you to have a signed contract.
Yeah.
But it's really to protect the client so that I don't come back and say, oh, no, I told you I was going to charge 50% instead of 1/3, okay?
Right.
There are a couple firms in town, bigger firms, that are now charging 40% pre-litigation. And I'm sorry, I've said it before, it's insane, okay? Because, again, the problem you have is if you got 100% of your settlement you're trying to recover, and you're paying 40% to an attorney, and you're paying, let's just assume, another 1 or 2% in costs, and now another 5 or 6% in health insurance, you're eating up your settlement. You're already getting to half of what your settlement should be.
Right.
Okay. So is it negotiable? Yes. Will I negotiate it? No, but what I do is I reserve the right to lower it at the end. In other words, what I've found over the years, I'll do what I can to be fair to a client in different ways.
Well, it's good business, and obviously you kind of understand. You get to know these clients. I mean, and that's the art of working by yourself.
Right.
That's the advantage, is that you get that relationship with your clients. And there are times when, and you've said this before, you don't want to ever make more than your client makes on a case.
That's my unwritten policy. I won't do that for a non-litigation case. If a case involves a lawsuit, that's a harder one to follow.
Yeah.
But for pre-litigation cases, that's just a good policy. But, I just had a case we settled. It was interesting. Very nice person. She actually is in the medical field. And she had gotten an initial offer just of $4,000 on the case. And so the short story is, brought the case in, worked it up. We got it settled for, I think, 15 or 16. But what we did is we took off the $4,000. So she didn't have to pay a full fee off of the full recovery because she had already gotten that. So she saved a little bit by doing it. So that does work into the issue later on. If you think about it, though, if you're in litigation, where again, sometimes you got to look and say, how much are you paying versus how much are you paying in attorney's fees, and is the expected recovery through going through a lawsuit worth basically taking the chance of that higher attorney's fees and costs?
Well, and that was one of the other questions that came up is, won't I get more money if I litigate my claim? In other words, if I sue them, won't I make more than if we settle it?
Let me come right back to that because Colleen's giving me a look.
Yes.
Go ahead.
No, you're good. Yeah, so one of my friends, she was actually in an accident. She was in the passenger seat, and they got hit from the back. So I kind of just wanted to ask questions on if you're in a passenger seat of the car and, you might not have insurance necessarily. I didn't know, where would the passenger go at that point? Because she had some hospital bills, and I think that she was really confused on if she needed to get her insurance involved or what exactly steps that she needed to take. So I didn't know if there were certain things that she needed to do.
No, that's a good point. The vehicle you're in is usually the primary insurance, okay? So you're saying she's in a car that doesn't have insurance, all right? So if in Kentucky, the first step, we're looking for what we call no-fault coverage again, which is covering the medical bills like we talked about. If I'm in Jim's car,
right,
okay, and you don't have insurance, and I didn't know that, my next step I fall back on my own car insurance. They can take that role of insuring me while I'm in his car, like your friend, okay? So she's a passenger, they can take that role. If she doesn't have car insurance of her own, let's say she just uses a bus all the time. In Kentucky, there's a thing called the Kentucky Assigned Claims Plan. which says you're in a car that you don't have any title to. You don't have any legal responsibility. They say to Allstate, Geico, whoever it might be, as part of doing business in the state, you're going to act like you have no-fault insurance for your friend, the passenger, and you're going to pay the medical bills the same way. Now, that person, okay, well, let's use Geico. Let's say Geico has your friend's claim. They pay out $10,000 in medical bills. Geico can then go recover whatever they pay from either the at-fault driver or the person driving the vehicle that the friend is riding in, because, again, she should have legally had that insurance, and she didn't, okay? In Indiana, none of that really applies. You're going to use your health insurance no matter what. You're going to use your health insurance, let it fall back that way. You wouldn't have – well, I shouldn't say none of that applies. In Indiana, it's a med-pay state. You're saying there's no med-pay on the vehicle you're in. The next step would be to fall back to your own family insurance, and that med-pay could kick in, okay?
Okay.
All right.
So,
and then your
her friend's
insurance.
parents' coverage might kick in to cover her.
Right.
Okay. Okay, that makes sense.
Does that make sense?
Yes, thank you.
Well, let me come back to the question then that we raised earlier. I think a lot of people would think, well, if we go all the way to trial, won't I potentially make a lot more money than settling, up front, maybe a few months in? How do you have that discussion with your client?
I'm sorry, I was trying to get a drink of water.
No, it's okay. Go ahead.
All right. Then the common misconception everybody wants to say is, sue somebody, it's worth more money. And that's not necessarily the case. And then, again, back to the TV advertisers, they want to all act like that, okay? It depends upon the value of the case. Because you got to realize right off the bat, well, okay, let's go back to something before we even get back to the attorney's fees. If you're going to trial, it is like going to the casino, okay? You are rolling the dice, all right? And that's because you're trying to convince 12 people, okay, that your claim is worth, so much dollars. And on the other side of that courtroom is defense counsel who's saying it's not, and this is why it's not. And any case that goes to trial is usually not slam dunk, okay? That's why it goes to trial. If it's really slam dunk and the insurance company knows that it's, there's no issue, it's going to get settled.
Right.
They're
They
not going
want
to
to
take a
limit
chance.
their loss.
Right.
Yeah.
Right. So nothing is slam dunk. And if it goes to trial, it's got to be worth it, because immediately if you jump from a 1/3 fee to a 40% fee, you've now got to make up roughly 6.5% difference. Okay. In addition, your court costs, as soon as I file a case, it costs me $300. Average deposition will cost $400 or $500. Medical depositions can cost anywhere from $1,000 to $2,000 per doctor or more. So, assume you've got $3,000 to $5,000 coming out of the case for court costs. All right. Again, you got to hit the ball out of the park to make it worthwhile. If you have the easiest example, and I have to do this sometimes with clients, if I've got, let's say, and I would have to run the numbers, but probably this would work, say $12,000 or $14,000 on the table without a lawsuit, and we think we can only get it up to 25 or 30, I guarantee you by the time you run that, it's going to be, they're taking a hell of a gamble for about a $3,000 or $4,000 difference in their pocket. Okay.
Right.
So it's another thing about trial. We talked about this, I think, in one of the podcasts. It's a lengthy process, because the first part of any case, okay, if you're in a car wreck, you're usually doing a pre-litigation claim, okay, where you're getting your case together, you're sitting here letting your client get their treatment, getting their medical bills paid, and you forward it on to the insurance company and say, I think it's worth this much, call me to discuss it, okay? If you can get that claim settled, great. The client's probably looking at a 1/3 fee, and they're looking at court costs, or not even court costs, but costs of maybe $100 or less. Okay, because it's you got charged $50 for medical records or copying costs or postage. Nothing too bad. On the other hand, if you're looking at litigation, now you file the lawsuit. You now have a defense counsel who's going to file an answer. They're going to send you discovery requests. You're going to send them discovery requests. You're going to do depositions. You're going to go from a quick process to, after you file a lawsuit, I think it's very fair to say your chance to settle that case again is probably not going to come up again until 8 to 12 months after you file that lawsuit, generally speaking.
And what a lot of people don't realize is defense counsel works hourly, so they don't have a problem stretching this thing out, because they're billing by the hour to the insurance company.
Right, and I'm not even say stretching it out. But they work hourly, so their job at that point is to say, okay, did we, has every T been crossed and every I been dotted to make sure that this is actually the claim that they think it's worth? So how do they do that? They say, well, Mr. Plaintiff, you're claiming personal injury. Well, let's go back and look and see what you had for the last 5 years and 10 years in your treatment. Because again, I mean, if you can go in front of a jury, if I go in front of a jury and say, my guy can't use his left arm because of this accident, that's really strong. But it's weaker if he can show medical records from 3 years before where he started complaining about, a lack of sensitivity and a lack of movement. That's their job, is to try to minimize it.
Right. And again, that's their job versus your job, which is try to get the maximum amount not only for your client, but also, as you said, the right-hand, left-hand thing to make sure there's the max left over for your client to walk away with.
Right. Well, and we always say in trial work that the plaintiff's job is the hardest because to convince a jury to award money, you've got to convince them that 2 + 2 = 4, okay? A defense counsel, all they have to do is make sure that 2 + 2 doesn't equal 4. There's a whole lot of options. It doesn't matter. They can, as long as they poke holes in your theory, they'll win.
Right. Right. You've got an uphill battle.
Right.
Most of the time.
Right. And don't get me wrong. There are cases that are definitely worth taking to trial, and there are definitely hands that are forced to trial by insurance companies. But again, that's where I think you find the right attorney right off the bat. You have confidence in them, and you trust their judgment because hopefully they've done it for years. And also, they might even have resources. I've told you before, I have resources where I will call other attorney friends of mine and say, okay, am I crazy? Or what is this case worth? Am I underselling it? Am I overselling it?
Right.
What do you think? Because, when I have a client and I want to argue that their back injury is worth $30,000, for months, I want to believe that. But a jury might look and say, Desmond, you're believing your own hype. So,
and that does happen from time to time. But hey, we all do that. Hey, Jim, I want to thank you for your time. We're going to do a wrap here in the interest of time. We've got a lot more of these questions, and so the follow-up episode is going to be kind of a continuation of this process where we're just going to field some questions that you've received, and we're going to kind of go through them. But at this point, we're just over a half an hour. Let's be kind to the listeners. We appreciate you guys following with us, and be sure to come back in about 2 weeks for the follow-up episode. Jim, thanks for your time, buddy.
Sounds good.
Yep.
Appreciate it.
Colleen, thanks. That's it for this episode of the Kentucky Auto Accident Podcast. Jim Desmond will be back in 2 weeks to provide information you need to know related to car accidents and motorcycle wrecks in Kentucky. Until then, check out AttorneyDesmond.com. You can also follow him on Facebook at Attorney James Desmond. Drive safely, and please remember to buckle up.